This is a summary of Lecture 1 on the Business and Commercial Law module for students studying Business Management at the University of the West Indies. The objectives for this lecture is as follows. Participants should be able to define law, discuss law and morality, classify areas of law, and identify different sources of law. Although our lives and behavior are regulated by a complicated system of rules, norms, and conventions, only some of these are defined as law. Our first introduction to rules come from our parents. Don't talk with your mouth full. Don't run up and down the stairs. Don't shout. And then at school, don't speak in class. Don't eat in class. Other rules are social norms or conventions, such as covering your mouth when you cough, or not dating one of your friend's exes, that sort of thing. But the rules that we are concerned with in the study of law are those that can be enforced by the state. Some rules have the force of law, while other rules or conventions will simply lead to social disapproval. If you break the rule, don't take someone else's property. You may be liable to pay a penalty that will be imposed by the state, that is, the offense of theft. If you drive carelessly and injure someone, you may be required to pay them compensation. On the other hand, if you, the day after your best friend breaks up with their boyfriend or girlfriend, decide to start dating him or her, you are likely to be subject to serious social disapproval, but no formal penalty will be applied. There are significant differences between societies when it comes to the kinds of behavior which will lead to disapproval and which kinds of behavior will lead to a formal penalty being imposed by the state. For example, while adultery is disapproved of in Trinidad and Tobago, most of the times, by most people, I would like to think, but you never know, it will not lead to formal punishment, although it may be grounds for divorce. By contrast, in Islamic law, adultery will lead to a criminal penalty being imposed. Differences between law and morality. 1. Laws are enforced by the state, whereas notions of morality are followed because of the fear of social ostracism, either from the respective religious perspectives or from the public generally. If someone disobeys the commands of law or violates the law, he is liable to be punished by the state, but if someone fails to observe the principles of morality, he is not liable to be awarded physical punishment. The most severe punishment that can be awarded to a person for not observing the principles of morality is his social rejection. Secondly, morality is concerned with both internal and external affairs of man, whereas law is concerned only with the external affairs of man. Thus, law punishes only those persons who violate laws by their external actions. For example, law punishes a person only when he commits a theft or murder. Or physical crime. Law cannot punish a person for telling a lie, unless while giving evidence in court, or for being selfish. Telling lies and being greedy or ungrateful may be considered sins by some people, but they are not crimes. Thirdly, there are many things which are illegal in the eyes of the state but are acceptable to morality. For example, most persons would not consider it a sin to drive without a seatbelt, but it is illegal. Fourthly, laws are certain and universal, and they are universally applicable to all citizens in theory. Although the Prime Minister recently said that the ganja laws must change in Trinidad and Tobago because this is not so, he said it's applied differently to the upper echelons of society and those that are less fortunate. The rules and standards of morality, however, are varied and uncertain and varies from religion to religion and individual to individual. Classification of law. Lawyers have generally classified the law into several broad areas, although this is complicated by the fact that some of the basic terminology has different meanings depending on the context. For example, there are at least 3 different meanings of the term common law. When contrasting with civil law, The distinction being drawn is between the English legal system and the family of common law jurisdictions, as opposed to the civil law jurisdictions whose systems are derived from Roman law, such as Germany, France, and Japan. There is also another meaning of civil law when dealing with the law within the common law legal system. As opposed to contrasting the common law legal system with civil law jurisdictions, civil law can be contrasted with criminal law. In this context, civil law is a form of private law and involves the resolution of disputes between citizens or businesses. Criminal law, on the other hand, is an aspect of public law in which the state will prosecute an individual for behavior that the state wishes to control and which is deemed to be morally reprehensible. An important distinction between civil and criminal law is in the standard of proof required for different types of cases. The standard of proof relates to the requirement for the facts of cases to be proved by evidence. How sure is the court that the evidence proves the facts? In criminal cases, the prosecution is required to prove the case in court beyond a reasonable doubt. This is a demanding standard justified by the fact that the accused is facing the possibility of a criminal penalty being imposed if found guilty. In civil cases, the standard of proof is on a balance of probabilities, a less challenging requirement, which means that the court merely has to be of the view that it is more likely than not that the defendant is liable. There is also classification of the law identified as public law and private law. Private law deals with relations between individuals where the state is not directly involved, such as the enforcement of contracts or ownership of property. Public law, by contrast, deals with the relationship between citizens and the state. For example, where an individual believes that their constitutional rights have been infringed by an action of the state. Judicial review is the procedure by which citizens can seek to challenge the decision, action, or failure to act of a public body such as a government department or local authority, or other body exercising a public law function. In an action for judicial review, the judiciary will assess the extent to which a public body or person has acted within their legal powers. This includes actions of government ministers. The classification of contract law deals with legally binding agreements between parties. Contracts are used to cover transactions relating to a wide range of issues such as sale of goods, sale of land, employment relationships, etc. Key areas of court action relate to breach of contract. We will be looking further at contract law later on in this course. The classification of family law deals with matters relating to family and domestic relationships. Issues dealt with in family courts include distribution of property and the breakdown of relationships, arrangements relating to children, and maintenance. A tort is a civil wrong which causes another person to suffer damage or loss. The law of tort covers a body of civil obligations, rights, and remedies. Where a person has suffered some sort of personal or financial damage as a result of the wrongful actions of another person, they may be liable under the law of tort to claim financial compensation. Key areas of court action relate to negligence, careless behavior, and defamation. A statement about someone which damages their reputation. Land law is the set of rules that govern the land and anything attached to it, such as trees, buildings, or anything in it. For example, minerals or oil. Key areas of court action relate to disputes over rights to land, rights across land, rights in relation to the use of land, and boundaries between neighboring land. Company law, of course, has to do with the legal issues regarding companies, and we will deal with this matter in some detail in this course. Turning now to sources of law. So the main sources of law made by the legislature, law made by statute, treaties and conventions. Statutes are law made by the legislature. Law made by parliament is referred to as legislation. Statute law, acts of parliament. They are written laws that express the will of the legislature. In Trinidad, the supreme lawmaking body is Parliament. Parliament has two chambers, the House of Representatives, comprising democratically elected members of Parliament, and the Senate, comprising members who are appointed by the President, with some senators recommended by the Prime Minister, some by the opposition, and some independently. A valid act of Parliament is written law and is the end product of a long process following the introduction of a bill in Parliament. Before a bill is introduced to Parliament, the government will normally, though not always, go through a process of consultation. Following consultation, the bill is introduced in Parliament, is debated, discussed, and amended. Once a bill has gone through all of the necessary parliamentary processes, it will be signed by the President and then published as an act. A valid act of Parliament takes precedence over all other law, common law or case law. In discussion about legislation or law emanating from Parliament, there is a distinction between primary legislation and secondary legislation. Primary legislation refers to acts of Parliament or statutes. Because it often takes a long time for primary legislation to get through all of the various stages in the parliamentary process, the drafting of acts may contain only broad provisions or rules, and then the detailed rules are produced later under the authority of the act. These detailed rules are known as secondary legislation or statutory instruments and take the form of regulations, rules, or orders. They have the force of law but can be implemented with less scrutiny than primary legislation. They are often given from ministers and other public officials such as transport commissioners, police commissioners, etc. Turning now to the other main source of law, which is judge-made law, also known as common law, also known as case law. Law decided in the courts, referred to as common law or case law, is the decision of judges in particular cases, applied by other judges in later cases. When we refer to the common law, in contrast to statute law, we are referring to the law contained in decisions of the courts rather than legal rules contained in acts of Parliament. Trinidad and Tobago is a common law system, meaning that many of the most fundamental legal rules and principles have been established by judges deciding individual cases, rather than these rules being laid down by Parliament. So for example, most of the law relating to the formation of binding contracts is to be found in the common law rather than in statutes. When a lawyer or judge is looking for the rules and the formation of contract, they will refer to important legal cases which set out the legal principles. In other words, they will be looking at case law or legal precedents which establish the relevant legal principles. The body of court decisions that comprise the common law has developed over many years, dating back to its origins in 12th century England, as the law in Trinidad and Tobago was once married with that of England. As mentioned earlier, there are at least three different meanings of the term common law. When common law is contrasted with statute law, common law is referring to the law found in the decisions of the courts rather than the legal rules contained in statutes or acts of Parliament. When referring to the distinction between common law and equity, equity developed as a body of law reflecting principles of conscience and designed to do justice in situations where the common law was not able to do so. Even though the courts of equity were combined with the common law courts in the 19th century, there are still two distinct bodies of case law, common law and equity. Modern courts will refer to certain principles or remedies as equitable, contrasting them with common law principles and common law remedies. Examples of equitable remedies are injunctions and proprietary estoppel. Turning now to the doctrine of stare decisis. This refers to the doctrine of binding precedent in which the courts are bound to follow earlier decisions, even though a judge in a second court might not approve of the earlier precedent. Stare decisis is a Latin term which literally means to stand by decisions already made. The idea of binding precedent in the common law system is to ensure fairness through consistency, to provide predictability in the law, and thus reduce the need for litigation. If people can determine what the law is, there is no need to litigate the case, and indeed, no point in doing so. Legal advisors can advise clients with confidence about what the legal principles are that a judge would apply in deciding a dispute in court and what the outcome would be. The rule of binding precedent is that the legal rule established in a precedent will continue to be applied in subsequent similar cases until either another court decides that the case was incorrectly decided or for some other reason cannot be allowed to stand, or until a court higher in the hierarchy overturns the decision, or until Parliament decides to change the law by passing a new Act of Parliament that overrules or alters the rule laid down by the court. So in summary, laws are enforceable by the state while norms and social conventions are enforced informally. Law has both broad macro functions and more specific micro functions. A principal social function of the law is the maintenance of different kinds of order, including social, political, and economic order. So as we saw at the beginning of this lecture, the unit objectives are as follows. Participants should now be able to define the law, discuss law and morality, classify areas of law, and identify different sources of law.